Lori Daybell was crying in a wheelchair today and got her trial delayed. Lori showed up and claimed to have nausea, headaches, and chills. Those in the court say she seemed to look different than usual, but the cause, it could have been a variety of things. The judge had this to say to Lori: "I'm your trial judge. My instructions are to complete your second trial. Even if for some reason your sickness worsens, even if this case got delayed into June or July or August, I'd still be your trial judge." To me, this is the judge who Lori has tried to get rid of repeatedly, calling bullshit. That's what I think this is. I think the judge does not believe her. So then, at this point, as far as my understanding is, Lori was not in a wheelchair. And she went outside the court to talk to her advisory council for a moment, and then returned in a wheelchair with her face in her hand. And they put a garbage can next to her. And again, people are saying that are in the court says she looks different. That could be a variety of reasons. I personally believe she is playing this up. And the longer this goes, the more I think you're going to agree with me. Lori Vallow's advisory council won't do the voir dire without her. Lori says, "I'm sorry that I'm sick. I did not plan on getting sick." The state, Trina K, mentions witnesses already had to be rescheduled to fly in. She needs a schedule for the witnesses. She suggests waiting until Wednesday with the same jury. The judge asks if he can start the oral voir dire with himself. Trina K mentions Lori is in a wheelchair, and the wheelchair says MCSO on the back. And the judge says Lori should be in a regular chair in front of the jury. Now, this should be no problem, right? She's sitting, so all they would have to do is transfer her to another chair. Jury would be there, and then she'd be able to, after the jury leaves, get put back in a wheelchair, right? Lori says she can't do this right now and wants to get better so she can represent herself. She says, "I can't control any of this." The judge made a very true statement. "I'm sure these jurors are going to be none too happy coming down today again for a dry run." Remember, she's already delayed things. Trina K and the judge try to figure out when to try to restart. Obviously, with how Lori is acting, tomorrow is not going to work. They settle on Wednesday, 10 a.m. But the judge needs to bring this jury in and tell them this. And Lori needs to sit in that normal chair for the jury to come in. Lori doesn't want to leave the wheelchair and throws a tantrum. "You are putting a lot of pressure on me to be better by Wednesday. If I'm not better tomorrow, are you going to drag me in here on Wednesday to bring me here?" So, if I'm not better on Wednesday, judge, are you just going to drag me here? And the judge responds, "Yes." The answer is yes. I will probably order you to be here on Wednesday. We will take tomorrow off. I need to confirm how you are feeling. And Lori suggests the judge come see her at the jail then. And he responds, "I'll take a pass on that." Ooh, it's getting snappy. It's getting snappy in here, understandably. Lori started loudly crying and wouldn't leave the wheelchair, so both Lori and the prosecution left, so it's equal on both sides. The judge is just shaking his head and has to tell the jury, no attorneys are here. He said, "I'm embarrassed to tell you because I've never had this come up in my entire career. Something else has come up now and we're unable to proceed with jury selection as planned. The situation is such that we won't be able to resume until Wednesday morning. I hate to ask you guys to do this and I apologize." The judge gives the usual orders to not look things up and to return Wednesday at 10 a.m. The judge says if they make it on the jury, he'll buy them donuts, and the jury is released. Now, I still have motions to go through because these all came down ahead of time. Because remember, the judge is done playing with Lori. He's going to give them as written motions now because Lori threw a fit. I think she's acting. I think she is playing it up. I think she is doing it for attention. I think she is delaying it for attention. And am I personally angry about this? Yes, I am. Yes, I am. Now, why would I be personally angry? Because, hey, this is just extra extended content, right? I can do more videos, the more problems she causes. I wanted to do a league launch with my friends on the 13th of this month. And if Lori has trial, that can screw it up. So, we'll see what we're doing when we get closer to there. There is still a chance that if Lori gives up causing issues, and they show up to court on Wednesday, and they then go to court, there is a slim chance that this trial could be done before my league launch. And then I wouldn't have any issues. I wouldn't have to make any decisions about, do I cover Lori that day? Do I play this with my friends? We haven't had a new updated league in this game in about a year now. So it's been a long time since I've gotten to play with them. So I'm torn, but I also am dedicated to covering this case, and we'll have to see if it's in, like, especially the final days, or I don't think there's any way I don't cover it. If Lori is, like, getting this trial delayed for a week and a half, and we're at technically day 2 of the trial, I might take the day off, come back Saturday, and do a video then. If it's near the end, I think that's how I'm going to handle it, just putting it out there, because there is a real scenario that Lori tries to delay this trial into, like, July or August, and the judge is seeing it too. I was thinking it. As soon as I started hearing what she was doing, I was thinking she is going to make this a spectacle, and the judge is feeling it too. So with all that being said, let's take a look at what's behind me. So, we have minute entry. The court has received and reviewed the following. Defendant's motion to dismiss for non-preservation of crucial evidence dated May 7, 2025. State's response to motion to dismiss non-preservation of crucial evidence filed May 17, 2025. Defendant fails to establish with any specificity. Words are killing me now. What additional relevant evidence could have been discovered had the actual car door and window been preserved by the police? Nor does the defendant assert that what additional testing, measurements, or analysis could have been done, those items preserved. Finally, the defendant also fails to assert how additional analysis would lead to exculpatory evidence, and it was denied. This motion was denied. I will say that if it was an actual lawyer making this motion, they probably would still get denied, but they could have made a much better argument, because I think the fact that that evidence was not kept is it's not good. I'll put it that way. It's not good. It's not a positive. And I think a actual lawyer could have maybe done something with that. This one here is receive the following. State's motion in limine preclude inadmissible evidence relating to Tammy LeChick, filed May 3rd, 2025. State's motion to file motion in limine preclude admissible evidence relating to Tammy LeChick under seal, filed May 3rd, 2025. Defendant's objection and request to unseal state's motion in limine preclude admissible evidence related to basically there's this woman that the state wants to preclude Lori from bringing in evidence about that's not related to the case. The defendant's request to unseal the state's motion in limine is denied. The specific conduct occurred on December 30th, 2024. I wonder what it is. But December 30th, 2024 does not implicate the witness character for her truthfulness, and the remoteness of that witness conduct occurring in or around December 30th, 2024, 4 years after she completed her work on the case, November 18th, 2019. I would assume that if this was like an actual crime, that, if it was an actual crime, people would have found it by now. So my only guess is that maybe she messed up something in a case that was like a newer case, and they're just kind of making sure that it doesn't get brought up by Lori because it's not relevant. Too great to make it relevant for her work in this case. While the specific conduct alleged would be relevant to impeach the witness's memory or ability to recall information on or about December 30th, 2024, it is too far removed from November 18th, 2019 to make the conduct relevant. I guess it could also be an injury. If she got like a head injury. No. If you got a head injury, you would do November 18th too. Drunk, maybe? I mean, I don't really want to speculate, but like too much, but could be drunk, could be a number of things for the 30th. Could be an actual family tragedy, right? Lori likes to use that word. Like, imagine you're at work working on a case and you get a call that your son was killed in an accident or something. And then you go to a trial and you're trying to recall evidence or something you did that day. And you can't because your mind was fully focused on that actual family tragedy. Like, there's a lot of things that could fit this that aren't, terrible. But we don't know. It is ordered provisionally granting the state's motion limiting regarding the state-specific witness on or about December 30th, 2024. Should the defendant think she has established through cross-examination some nexus between that conduct and the witness's work on this case, the defendant shall ask outside the presence of the jury to reconsider this ruling before asking questions regarding the witness's conduct on or about December 30th, 2024. All right, so this one here is going to be defendant's motion to preclude evidence of phone data and text messages, state's response to preclude evidence of phone data and text messages, and defendant's reply to state's response in motion to preclude evidence of phone data and text messages. The defendant argues phone data and text messages related to Alex Cox should be precluded for two reasons. The messages are hearsay. The information was illegally obtained. Alex Cox's text messages are admissible pursuant to rules of evidence and are specifically defined as not hearsay if the statements are made by the party co-conspirator during and furtherance of the conspiracy. The defendant cites stored communications in support of her assertion that the phone information was unlawfully obtained. However, the same act in section 2703 states the content of wire or electronic communication, electronic storage, etc. are only accessible by the government pursuant to a warrant. The defendant goes on to cite various requirements for pen, register, and tap and trace warrants, which are not applicable in this case because they are not the types of warrants issued in this case. Those warrants refer to ongoing monitoring of lines, commonly referred to as wiretaps. Defendant's reply admits warrants were issued, but argues they failed to acknowledge that the state courts and law enforcement are obliged by federal and state laws to ensure the revised or amended statutes are followed. It is not the state's burden to establish any of those things. It is the defendant's burden to establish the warrants were not lawfully obtained. If a warrant has been issued, there's a presumption that the warrant is valid. And they have case law for that. The defendant has a limited right under the Fourth Amendment of the United States Constitution to challenge the validity of a search warrant by converting the factual allegations made in affidavit in support of the warrant. The defendant must show that a misstatement or omission in the affidavit was deliberate or reckless to the affiant's part, and that the misstatement or omission was material to the finding of the probable cause. The defendant did not attach the individual warrants nor the affidavits associated with any warrant. Oh, she didn't do her job. Finally, other than making a statement that the information collected from an iCloud account and or storage sources went beyond permissible scope of the warrant, the defendant has not submitted any evidence of that. It is ordered denying the defendant's motion to preclude evidence of phone data and text messages dated May 5th, 2025. All right, so here we go. And this is defendant's motion to suppress all evidence pertaining to Jeep Wrangler license plate. All evidence pertaining to Jeep Wrangler license plate. All about the Jeep Wrangler's license plate. The defendant's motion alleges the Jeep was seized in Idaho without a warrant, which is apparently not correct. That's an amazing open. Just begin with, she's wrong. The defendant's reply states she received late disclosure, which revealed the Jeep was in fact seized pursuant to a warrant. Okay. The Jeep was held in police impound until a second search warrant was issued, at which time the search of the Jeep was conducted. Whether the state did disclose the information late is a separate issue to be dealt with separately. So the issue is, with this Jeep, is there was a number wrong on the year of the model. They had a valid search warrant. They impounded the Jeep. If I'm remembering right, they saw the model year was 1 year off. They sent it off to get a second warrant, and then they went into it. And the judge is even kind of helping her here. Whether the state did disclose the information late is a separate issue to be dealt with separately. So he's like, file that motion. But late disclosure does not impact the substance of whether the issued warrants were valid or invalid. The defendant asserts without evidence the Jeep was unlawfully seized. The defendant attached no copy of the search warrant in question. Again, Lori didn't do her job. If a warrant has been issued, there is a presumption the warrant is valid. The defendant has, and this is all, we've already read that about the limited right. As has been explained to this defendant previously, just making a statement that something is unlawful is not evidence. There's some snark in there. Nor does a conclusory statement create a substantial preliminary showing that any statement in the affidavit was materially false. Here, the state does acknowledge that the wrong number year, so I was right, for the Jeep was listed, but that would hardly impact the determination of probable cause to issue a warrant. The defendant has presented nothing more than a hyperbole alleging the warrant is invalid. She could have attached the warrants in question and pointed to specific statements herein to support her assertions, but failed to do so. The defendant has presented no evidence which warrants a Frank's hearing. It is an order denying the defendant's motion to suppress all evidence pertaining to the Jeep Wrangler. So. He denies all of her motions. Yeah, Lori, I think, she's either not sick or she is slightly sick and she is playing it up. That's my thought. I do not think she's actually ill. Like, to the severity where she's going to be in a wheelchair with a garbage can and crying, breaking down in court because she doesn't want to move to a regular chair. No, I don't think that's the case. I don't think that's the case at all. I think what happened is, if I'm getting my timing right, she knew she was gonna lose all these motions. She pretended to be sick last week, and then, or played up being sick last week. She is either slightly ill this week or has put on makeup or something to look slightly ill this week and is now playing it up for a delay after complaining that she wants a speedy trial. And I think the judge clocked it. I think the judge clocked it that she's trying to do this to get a different judge. And there's a lot of delaying she can do. And the question becomes, what do they do if Lori continues this, right? Because I talked about it, and part of the reason I mentioned it is I have that, part of the reason I mentioned it is because of the coverage. I have that league launch thing in that game that I play with friends. But there's a real scenario where we get to the 13th and it's like day 3 of the trial. And that should be thought about, right? Like, eventually, I have to assume they bring in her advisory council and they go without her. I don't know what that point is. How long do you let her do this, right? If she keeps going, how long do you let her do this? And we know Lori is getting information from the outside because she has mentioned YouTubers, right? And like channels and interviews. So if her lawyers are like telling her updates of what people think and stuff, she could feel emboldened to continue. And I don't know what that process would be. I saw that Nate Eaton and a few others, I think, are going to be on Fox 10 later, and they're going to talk about today. I'm hoping they've got someone there that will like understand the process of what do you do if a defendant is pro se and then purposefully stops the court process. What do you do? And do they have to make a determination it's purposeful? Or can they say she's too sick to be her own lawyer, therefore we're continuing with a public defender or whatever, right? I don't have answers, and I'm very curious because she's not getting her witnesses, right? We know that. She's not getting her witnesses, and she failed to get rid of the aggravation stage, which she got mad about last trial. So her revenge tour is limited. I looked at the witness list. There's not as many people, individual people, for her to really target on the state's list. Like, we saw how she targeted some people and really went in on them in the last trial. So it could be her punishment is going to be delaying the case, and that becomes part of the revenge tour. That's entirely possible. Yeah, that quite a mess. Now, I'll mention this right at the end. Mike Lindell's court case began today. Because this is delayed till Wednesday, I thought about covering it, but there's no video in the trial. I couldn't find anyone at the time doing like a live update feed on like Twitter. Maybe they're not allowed to tweet from the courtroom. Maybe there's no media allowed to do that. His own news media is doing some sort of like weird coverage. I'm sure it's great. Before going into court, though, he blamed things like China and Satan. So I hope those are in his legal defense. I really do. That would be very entertaining. But no matter what, we'll probably cover highlights of that when like newsworthy moments happen in that trial. I can't imagine he wins. I'm going to be honest. Like, he's said and done too much. His lawyer does not give me confidence. His lawyer went viral for appearing in a Zoom court call without pants and walking around. His lawyer went viral. If you haven't watched my video on it, I highly recommend it. His lawyer went viral for submitting court paperwork that used AI that just created cases. Just made up case law. Talked about real cases and made up conclusions. That's who he's put his faith in for this. I don't think, I wouldn't have faith he's going to win if he was innocent. You know what I mean? And I personally don't think he's innocent of it from what he's done. So, that'll just be on the back burner. That's going to be on the back burner. Anything else? I haven't covered any of the mushroom case, in Australia. I will say that I love I'm gonna butcher the name. Live from My Sofa. I'm loving his coverage of the mushroom murder, and I've just been enjoying it. And again, I know the Karen Reed stuff's going on. I didn't keep up with the first trial. I tuned in periodically. Haven't kept up with the second trial, but I do wonder. I feel like at least the reaction from the public is that the prosecution has screwed everything up. Whether she's guilty or not, they've screwed it up to the point that they don't think she's going to be found guilty. So personally, I'm going to be watching for that verdict whenever that comes out. But this is Lori. This is what Lori does. She does an act and fails motions. See y'all in the next video. If you like the content, make sure you hit subscribe. I have a full playlist about Lori, and you can, if you're just coming in now and you're like, who is this woman? I'm sorry for what you're about to learn.